Hey all, Professor Tracy here, back with another contracts video, this one on the defense of mistake. So we're continuing with our march through the defenses to formation. And this time we're looking at mistake, which encompasses both what's called mutual mistake and then unilateral mistake. When we're looking at this topic, there's a few things we want to make sure we walk away from this lesson understanding. And one is, what is the difference between a mutual mistake and a unilateral mistake? And then we want to make sure we know one of the elements of both types of mistakes is what's called a basic assumption, that the mistake that's made by the parties or one of the individual parties must go to a basic assumption of the contract. Well, how do we know how to identify what constitutes a basic assumption of the contract? We also want to be able to determine whether the impact of that mistake is material, because not every mistake, even if it's about a quote basic assumption, will be sufficient to work for the purposes of the defense of mistake. It has to go to something that's material about the agreement. So we're going to look at that, and then we'll see that one of the exceptions, that even if all the elements of mutual mistake or unilateral mistake are met, there is still this exception that potentially applies, which is if the party claiming mistake bears the risk of a mistake, then they're not going to be able to claim the mistake as a defense. And we'll see how that works in practice. So we need to understand, well, how do we assess whether someone bears the risk or not? So let's start with mutual mistake, which is far more common in terms of successfully being able to argue the defense of mistake. Typically, what's in view when someone talks about the defense of mistake is mutual mistake, because that's what is typically what works as a defense. Unilateral mistake is harder to assert as a defense, and we'll talk about why when we get to it. But with mutual mistake, then, here is the restatement rule, which we can read it out here, right? Which says where a mistake of both parties, that's why it's mutual, both parties at the time of contract formation. So remember, that's still what we're looking at, is something that occurs at formation, was made, right? A mistake was made at formation as to what? A basic assumption on which the contract was made has a material effect on the agreed upon exchange of performances. The contract is voidable by the adversely affected party unless she bears the risk of mistake. So it's a wordy rule, but all the elements are in there. But as we do, let's chunk it and break it down into its constituent parts, into its elements. So we need both parties at contract formation. So there's kind of two things in that one element, right? That we need to make sure, if we're trying to argue mutual mistake, that we want to make sure that indeed both parties have made the mistake, and that whatever mistake they were operating under was true at contract formation. So timing is part of what we're looking at in number one there too. And the rule says they make a mistake. And we'll talk about exactly what that means and about what? A basic assumption of the contract. And 4, it has a material effect on the agreed performances that the parties are going to be providing or proffering. And there is that exception, that it's not available to a party who bears the risk of mistake. So that is breaking apart all that the restatement rule said. But let's look at each of those elements. Both parties at contract formation. As we said, it's both parties, right? Meaning that it's not unilateral. Unilateral is, we'll see, is one party, which is why it's called unilateral. And it must exist at contract formation. And that timing is key, because if the mistake is if what occurred is something that happened after formation, that is not the defensive mistake, right? If it's that, I buy all the cotton coming on some ship to the United States, and at formation that ship is afloat, it's still on its way to the United States, and we both believe that to be the case, then that is not a mistake if it then later sinks on its way here. You can't say, well, at formation you both believed it would arrive. That's true, we did, but that is a question of at formation, the ship was still afloat, still on its way. So factually, our beliefs were correct at formation. That is something that occurred after. So you want to make sure whatever it is where you're looking and go, well, they were wrong about that, or were they wrong at formation? Or are they wrong because of something that occurred later? And if it's because of something that occurred later, then that ain't mistake. It can be something else, one of what we're going to call the changed circumstances defenses, but it ain't this. So the timing there is significant. Then when we say make a mistake, what do we mean? We're talking about a mistake of fact as opposed to some other possible mistake, like a mistake in performance, right? That if a painter paints a house and they do it the wrong color, that's just a breach, right? Like that's just they improperly painted the house. That's a breach. You can call that. They may have done it accidentally or mistakenly, but it doesn't matter, because a breach of contract is just straight up strict liability. We don't care whether it was accidental or on purpose, etc. You did it. So that is not the kind of mistake we have in view here. Misunderstanding, if there's a failure to communicate between the parties and the painter thought the owner said one thing and the owner intended another, that's not the kind of mistake we're talking about. And what you might think of as a typo, so with words, that there's typo, that the color, in this case words, are written down incorrectly. So a Scrivener's error, whatever you want to call it, or a math error, that kind of thing is, again, it could be, particularly in the case of a unilateral contract, then yes, that well could be the kind of mistake we're talking about. But in the case of a mutual mistake, typically it is not. Instead, it's a mistake of fact is what we have in view. This here, which is this kind of situation that at formation, they were talking somewhere other than the house that was going to be painted, and they both believed that the house was intact and standing at formation, so it could be painted. But in fact, it had burned down. So that went to a fact. Note that house, even if it wasn't stated in the contract that the house was standing, they both assumed that to be the case. And that was a mistake about what the actual facts were, and they both believed it. So that's the kind of mistake we're looking for. And it has to be about a basic assumption of the contract. And I said that being able to assess or understand whether something is a basic assumption of the contract is essential, and walking away from this. So what do? We're asking, what are the factual assumptions the parties made when they entered the agreement? And one way of knowing that is saying, what is it about the facts that they are assuming? And if those things had been different, would they have still entered into the contract? For instance, if they had known the house had burned down, clearly they would not have entered into a contract to paint that house, right? So that they would not have done that. So even if it's unstated, that is a basic assumption of the agreement, that there's a house there to be painted. And so would they have entered into that had they known it was burned? Of course not. So that's one way of getting at, well, this mistake goes to a basic assumption of the contract. So we can have an example here with Bob and Bo, where Bob says, Bo, I heard you're selling your house. How much are you asking?
You heard that, huh? Well, it's true. I'm only asking $100,000, but anyone who buys it will have to assume the mortgage the bank holds on the property. Without the mortgage in the mix, I'd be asking for more.
That makes sense. How much is the mortgage?
It's $50,000, so I would be asking $150,000 for the house without the buyer taking over the mortgage. See, it evens out, right?
Yeah, I get it. It all sounds good to me. I'm happy to pay you $100,000 for the house and take over the $50,000 mortgage.
Perfect. I'm glad to sell the house so quickly.
After the parties enter into a contract, Bo discovers that the amount owed on the mortgage was actually $10,000 rather than the $50,000 he and Bob had assumed.
Bob, the bank says the mortgage is $10,000, not $50,000.
Wow, that works out well for me.
Well, yeah, but that's not how this works. We both made a mistake. We assumed the mortgage was $50,000 when we contracted, and it's not. The $100,000 price we agreed to doesn't make sense.
Makes sense to me. I get the house for $40,000 less than we assumed.
No, you're either going to pay me the additional $40,000 or I'm going to sue to rescind the contract.
Whoa, hold up. I thought we were friends. You're threatening to sue me? That's not nice, Bo. A promise is a promise. You promised to sell me the house for $100,000, plain and simple.
Really? Well, I'll see you in court then.
So here, if you look at it, right, and you're asking, okay, does this have an effect on the agreement that it has a material effect, right? Because of the fact that there's a disparity in so here's what we'll see, right? The standard we'll see with the material effect is a severe imbalance in the agreed exchange results in unfairness, right? So you see it something like this, that one party is receiving much more than they respected, like Bob is receiving the house only for the financial commitment of $110,000 rather than $150,000. So he's getting a windfall of $40,000. So he's much better off. And the financial benefit to Bo is now $40,000 less, right? Because it's not like he has $40,000 of debt hanging over his head he's getting rid of and pawning off on Bo. That's not there anymore. And so he doesn't have to worry about that, and that's not of benefit to him. So he's only getting a $10,000 benefit by Bob assuming the mortgage. So he's getting much less than what's expected. And so the mistake they made would have a material effect, right? And you can see this here if we have this is a different example, right? We're looking at example 2 here. And so August 23rd, now we have Bob and Herman, and Herman says, Mom, I'm looking for timber. I heard you have a big piece of land up in Ocala with 140,000 trees on it. Yeah, that's right. I don't care about the land itself, but I want the timber. I'll pay you $12 million for the land with all the trees. I'll sell it for $14 million. Sure thing. It's a deal. 2 days later, on August 25th, Everything's signed and official. See you at closing. So here we see, right, this is the agreement that they entered into, that Herman's going to pay $14 million for the land. Remember, he wants the trees. They both are aware that the purpose of the purchase is to get the $140,000 or 140,000 trees that are on there. He's already paid a deposit of $2 million. He's going to pay the balance of $12 million at closing, and Bob is going to convey to him the deed to the land. And the closing is set for October 28th, and they have both signed this agreement. Unbeknownst to Bob and Herman, all the trees on the Ocala property had been destroyed by fire on August 2nd, 23 days before they formed their contract. So at formation, we can say all the trees were gone. Herman finds out about the fire on October 1. Bob, I just learned that at the time we entered into our contract, the trees were no longer standing on your Ocala property. They all burned on August 2nd. Well, I didn't know that. It's not like I was trying to hide something from you. I get that. I'm not accusing you of anything. Still, we both honestly understood that we were buying and selling a piece of property with 140,000 trees on it, but it actually had 0 trees on it. So, what do you want me to do about that? I want out. I want my $2 million deposit back, and I don't want to buy your property. Contract is a contract. Trees or no trees. I expect you to buy the property. So if we were looking at this, both Bob and Herman at formation, right? At formation, believed there were $140,000 trees on the property at the time they entered into the agreement. But so both of them had that belief. It's a mistake of fact, right? Because they believed that there were trees on it. The facts were not, what they believed was not factually true, right? It's not a mistaken performance. It's not some miscommunication they've had. It's not some sort of typo or something like that. This is a straight up, they believe something that was untrue. And even if they didn't spell it out clearly in their agreement, it was what they believed to be the case. It goes to a basic assumption, right? Because why? They would not have entered into the agreement that they did, even though you're like, well, Bob would have. No, he would not have been able to enter into the agreement that he did had they known. Herman wanted it, and Bob knew that he wanted it for the 140,000 trees. And that contract would not have formed had they known the facts. It would not have formed at all if they had known those things. So that agreement would not have happened. So it went to a basic assumption of the contract, and it had a material effect. Why? Because Bob would be getting a windfall, right? Because with the timber on it, with a resource on it like that, one, we could say the price is going to be greater. Also, he's getting Herman to buy it regardless, right? So Herman's getting much less than he expected. The whole reason he wanted the property has disappeared. And so the benefit he's getting from the transaction has disappeared. But Bob is still getting, the price, the kind of price he would have gotten if there were all that timber on it, as if there were all those resources to be harvested and sold. And they're not. So it had a material effect on the agreed performances of the parties. Does it fall in the exception? No, it didn't in this case, right? Because there's nothing to show, and we'll talk just right about now about what the exception is, but about how do we know whether somebody bears the risk. To be fair, here, neither party, here, the person asserting it, who's getting the short end of the stick, Herman would be the one to be arguing this, right? Because he's the one who is aggrieved. So obviously he's the one asserting the defense, and we would ask, does he bear the risk? He does not. and we'll see why, right? There are three possibilities when we're asking whether somebody like Herman bears the risk of mistake. One would be to say, does the agreement itself allot to that party the risk of a mistake? The risk of a mistake. And you might say, well, how would that look? Often it's something like an as-is provision, like you're buying this property as is, or you're buying this property. It's some version of as is probably the most likely way for that to happen, or you're waiving all the inspections and things, which is and effectively saying, I'll take it without giving a thorough look at it. Then that you could lay that out specifically in the agreement, but that could also be this second way of where somebody bears the risk. But if there's there's an as-is provision, then the buyer, Herman, would be bearing the risk, right, of any sort of mistake. Conscious ignorance is saying, I realize I don't have full knowledge of the situation and I don't care. So depending if the agreement itself were to spell out that, there's not going to be an inspection, et cetera, then we could say the risk was allocated to Herman by agreement. But if it's a situation where he's like, I've never visited the property, I'm not going to go look at it before I buy it, I'm not going to have anybody else look at it before that, then he knows he doesn't know anything about the property other than what he's been told and what he believes about it. So he has conscious ignorance and he's plowing ahead with the contract. We would say the risk of mistake is on him because he knows he doesn't have full knowledge and he really doesn't care. And then the other possibility is sort of this catch-all where the court can say, well, there are other reasons to allocate the risk of mistake to you. Sometimes that's because there's a party who should know, maybe because of their experience or their expertise in a particular area, their how many what incentives they have. If, for example, you're somebody who is opening up restaurants and one of the things your restaurants do is you have a bar and you're serving alcohol and you're building a restaurant somewhere and don't bother to check to see, is this a dry town? Can I actually get a liquor license? Is that something I can do or not? And you should have expertise there of like, you open up these restaurants all the time. Then we're gonna, even if it's not conscious ignorance, we're going to allocate to you the risk of mistake because you're the one who had the reasons and the incentives to look here and didn't. So things like that are often why, but it's basically a catch-all where the court can say, in fairness, the risk of mistake should be given to this party or that party. So let's revisit this example too with Bob and Herman and the land here. So remember, they signed this on the 23rd, or they came to an oral agreement and then executed a written agreement, and then on the 25th, they came back together, and we have this situation where Bob says, are you sure you don't want to look over the property and have it inspected or something before we sign all the paperwork? No, I'm good. I mean, it's trees, right? Let's execute the paperwork and be done with it. Okay, suit yourself. Everything is signed, official. See you at closing. So there, if we were looking at this, the agreement itself, right, the contract they entered into is not what would allocate. So remember, Herman ends up being the party who's asserting the defense of mistake because he's the one aggrieved, right? It's still an assertion of mutual mistake, but it's the aggrieved party that's going to assert it, right? Not both of them. It's the party that's like, this mistake hurts me because I'm getting the short end of the stick now. I'm having to pay, $14 million for a piece of property that doesn't have any trees on it, and I wanted it for the timber. And A, there's no timber, and B, it certainly isn't worth that amount without the 140,000 trees on it. So he's going to be the one asserting it, but just because one party is asserting it doesn't make it unilateral mistake. He's asserting the argument of we both made this mistake. It's a mutual mistake. Mutual mistake does not mean does not mean that both of them are asserting it. That's not how these defenses work. It's still going to be one party asserting it, but they're asserting that they both made the mistake. And here, even if we went through and said, oh, he can satisfy all the elements, and that the exception didn't apply, but now I've changed the facts where he's specifically going, I don't want to look at it. I know I've never seen it. It's trees. What big, how, what am I going to do? Just go look at the trees. No big deal. He's never seen it. And there he has conscious ignorance. So he would bear the risk of mistake. He would not be able to assert it as a defense. So that is mutual mistake. Unilateral mistake is really similar, but it's got a really, really lengthy rule here. It says where a mistake of one party at the time of contract formation was made as to a basic assumption on which the contract was made has a material effect on the agreed upon exchange of performances that is adverse to her. So here, remember, it's one party who is saying, I was mistaken, as opposed to the party asserting we were mistaken. The contract is voidable by her unless she bears the risk of mistake. And this is the thing. We have to satisfy one of these other possibilities that we're adding for unilateral mistake, because the whole first part of what we just read is no different. No different is incorrect. It is very close to mutual mistake. It's just limited to one party rather than both parties, right? But there's these additional A or B, and one of these, it's an or, one of these has to be satisfied. Either A, the effect of the mistake is such that the enforcement of the contract would be unenforceable, right, would be unenforceable. That should not be the word unenforceable. That should be such that enforcement of the contract would be unconscionable. So talking about a mistake, I made a mistake, but that's a typo, a misspelling. And on my part, I guess a typo, since I didn't misspell the word, it's just the wrong word. It should be unconscionable. So that word makes a big difference here. It should be unconscionable. Or B, the other party had reason to know of the mistake. Or her bad faith, again, what am I doing? Asleep at the switch here. Should be her bad faith caused the mistake. So let's say that if we break it up, I believe my elements themselves are okay. So the elements are similar, right? The first part, instead of both parties, is one party at contract formation and then makes a mistake about a basic assumption of the contract, has a material effect on the agreed performances. And we think about the exception. Does the party bear the risk of mistake, either because the contract allocates the risk of mistake to them, there's conscious ignorance, or the court decides that it's going to, in fairness, allocate the risk to one party or the other. So then these additional elements are that, oh yes, I got it right there. Enforcement of the contract is unconscionable, saying, okay, it's unconscionable, or not both of these, one or the other. The other party had reason to know of the mistake or caused the mistake. So we would say, did the other party had reason to know of the mistake or caused the mistake? So either we need one of these, not both, it's an or. So we need one of those in the context just of unilateral mistake. So what do we mean when we say unconscionable? We just talked about unconscionability fairly recently, 2 lessons ago. And what do we mean? Well, it means the same thing. When we say unconscionable, it's exactly what we're talking about. There's procedural unconscionability, remember, and substantive unconscionability, which together comprise the defense of unconscionability. And when we talk about it, though, the thing you might say, like, well, why wouldn't you just argue unconscionability? And here's why. Because that is a very good question and an important one. But typically, the way courts deal with this is they say, if there is indeed a mistake, if there indeed is a unilateral mistake, that the person has made a mistake of fact about a basic assumption of the contract, it has a material effect on the agreed performances of the parties, then that constitutes unfair surprise. The mistake itself would be the unfair surprise. And so it's like you automatically get the procedural part of unconscionability satisfied. And then remember when we talked about substantive unconscionability, because we said that that with a mistake, that remember we said a material effect often means that it'll be an uneven. Now, and that's part of what goes to a material effect. Now, keep in mind, this is not one for one, right? Because when we talked about substantive unconscionability, we said there's either an overly harsh allocation of the risk or there is a gross disparity in the price or the value of the things being exchanged. Something can have a material effect on a contract, right? The mistake of fact can have a material effect on the agreement, even if it's not substantively unconscionable, even if it's not a great disparity in price or an overly harsh allocation of the risk. But it points us in the right direction, right? Because inherent in mistake is this idea of, well, it's got to be material and has to have a material effect on the agreement, on the agreed upon performances. Well, for us to know that, it is pointing us toward the possibility of it being one-sided, right? That it being more beneficial to it, like, and perhaps grossly so, right? It could be. You'd have to look at how extreme it is for it to be unconscionable. And that's why the element is there. It's saying, okay, normally you want to think in your head, unilateral mistake, the default rule is actually unilateral mistake is not a defense. It is not, right? It goes right back to things we said when we talked about non-disclosure. It goes right back to things we talked about, such as caveat emptor and buyer beware. The fact that I may think something is worth, like, oh, that is a genuine whatever painting, and I buy it, turns out it's not, and I think I got this good deal. That is a unilateral mistake that is on me, and there's nothing I can do about it. Right? That is not a defense. And I can't go, well, it's unconscionable. I paid $50 for this. And it's actually a piece of garbage. I thought it was, a Van Gogh. And that is not how that works. Right? Normally, unilateral mistake is not a defense, which is why there are these additional elements. So, not only do you have to show that there was a mistake of fact, that it was about a basic assumption of the contract and had a material effect on the agreed upon performances, but also either that it was unconscionable, that it resulted in a transaction that was actually in fact unconscionable, then, or we'll see, there's this question is, if the other party knew that I was laboring under mistake and was basically trying to take advantage of me, right? That's what we're getting at with the second possibility. Here, we're saying at some point, even in a unilateral mistake situation, the mistake I made caused me to enter into an agreement that was really so one-sided and ridiculous that it was unconscionable to me. So the other thing is, like I said, is one possibility. We said you don't need both. Remember, with unilateral mistake, yes, there are additional element of either showing unconscionability or showing that the other party knew or caused the mistake to occur. If they caused it to occur, obviously they know. And obviously, depending on that, the causing mistake, potentially, depending on what you're talking about, could give rise to something like misrepresentation or something along those lines. But here, what are we talking about? You knew or should have known, right? So the party doesn't have to know for sure, but they should have known that the other party made a mistake. They knew or should have known. And one way that should have known comes up is what's called a palpable error. And even though the video is getting to the end here and you're dying just to slide the thing to the end, I know, And you want to just pause for a second. And palpable error is what we mean by that is it's an error that somebody makes. Say, like the classic example you'll see is somebody calculates their bid, they're a general contractor, they're calculating their bid for a job, and they leave off a zero. They intended to say $5 million for the job, and they wrote 500,000. Well, a palpable error is so obviously wrong, right? If it's the kind of job that the person who's seeking the bids, say the government wanting a school build or something, if it's the kind of thing that's going to be about a $5 million job or a $4.5 million job or a $5.5 million, if you see a bid for $500,000, it's so obvious or palpable that the government should know just by looking at it. So the error is so obvious that that we would say, no, you should have known, right? That there's knowledge just by the fact that the error is deemed palpable. That's all I wanted to say there. So if we look at an example here with Bob and Barb, getting at the idea of a unilateral mistake that Bob's going to make here. Bob, can you take me up to Tallahassee on June 7th? I have a meeting up there and need a ride. I think so, but let me check on some things first. Hey, Bo, can I borrow your car on June 7th to take Barb up to Tallahassee?
Sure, but be careful with my car.
Thanks, buddy. Of course I'll be careful. 2 months later, on May 30th, remember she was asking for the ride on June 7th. Barb, hey, sorry I took so long to get back to you about the trip to Tallahassee. I've confirmed everything. I'm willing to take you if you'll pay for gas, snacks, and $150 for my time. About time? I thought you were dead. You're always so generous, Bob. Gas, snacks, $150? Really? Fine. I agree. I'll see you bright and early on June 7th. The day before the trip,
June 6th.
Hey, Bo, I just wanted to confirm that I can still borrow your car tomorrow to take Barb to Tallahassee.
Oh, I forgot to let you know. I actually don't have a car anymore. I totaled it the middle of May when I got hit by an ice cream truck.
Huh. Well, that's not good. Barb, I won out of our deal. I made a mistake. When I made the contract with you, I thought I could borrow Bo's car, but, well, he doesn't have a car anymore. Well, I didn't make a mistake. Why is it that this kind of thing always happens with you? So there's this question of unilateral mistake, right? If we're looking at this, the exceptions. Well, I don't want to finish. When we're looking at this, so think through our elements here of mistake, right? It's Bob who wants to get out of the agreement. He's the one, the aggrieved party, and he's the one who made the mistake, right? So if we think through our elements, there's one party, Bob. At the time of formation, he assumed that he could borrow Bob's car. And in fact, he did arrange that prior to actually entering into the formal agreement where he's going to take Barb to Tallahassee. Barb's agreeing to pay for snacks and gas, etc. And that, so it's a basic assumption of the contract, right? That they need a car. They would not have entered into any such agreement had there been no car. Bob would not have been able to offer to take her up to Tallahassee had he known he couldn't get a car. And certainly Barb would not have entered in any agreement with Bob if she knew he couldn't get into, didn't have a vehicle to get her there. So we can look at that and say, okay, that goes to a basic assumption, had a material effect, right? Because now Although Bob would be still getting, I guess, snacks and money and whatever, $150 and gas and snacks. Presumably there's no gas to be paid for, but snacks and $150. And Barb's getting nothing, not getting any rides at all. So it has a material effect on their agreed upon performances. And if we say, well, does the exception apply? Does Bob bear the risk? He's the one asserting it. He's the one we need to ask, did he bear the risk? And the answer is their agreement didn't allocate the risk to him. And we would also look and go, okay, what about, was there conscious ignorance? Was it the kind of situation where he knew he didn't know? No, he arranged things, right? And you can say, well, he should have followed up sooner. Well, maybe, but I don't think that rises to the level of what we would call conscious ignorance, where you're just like, I don't care, just move ahead, let's just do this thing. That's not the kind of situation we have. And there's not, and you could say, is there some other reason to allocate in the risk? Not really. Not really, right? There's no situation we go, well, Bob's the right person to have, bear the risk here. I don't think there's anything compelling necessarily that way. So it boils down to then of if it's a unilateral mistake because Barb didn't think anything one way or the other about whether he was going to be able to get a car from Bo. Right? She was unaware of that whole thing. You could say, oh, well, didn't she believe she was going to get a ride? Sure. But didn't have any sort of belief otherwise, right? Specific about Bo having the car and being able to provide it. That's all just limited to Bob. And we would say, well, is it unconscionable to hold him to this? Well, maybe. Maybe. Certainly there's procedural unconscionability because there's unfair surprise. So we would say that's satisfied. But I don't think, looking at it, I'm not so sure, right? Obviously, he's unable to provide the performance. If it's unconscionable to anyone, it's actually more unfair to Barb than it is to Bob in this circumstance, right? So realistically, maybe Barb would be the person who is more likely to just want to get out of it, right? Because what is she getting out of this situation? She's actually the aggrieved one. Bob's not. So in that sense, it makes it awkward to argue that it's unconscionable for Bob to be, even though I set it up here where Bob's the one arguing he wants out. So maybe in that sense, it's not a great way I've set it up. It's not great, but I think as it is, it's not unconscionable for Bob, and there's no indication that Barb had knowledge, etc. So as it's sort of teed up here. So here, and we already went through the exception and said no, he doesn't bear the risk. So that's it, right? So it's mutual mistake, unilateral mistake, that either one, remember, is a defense that the aggrieved party is going to be asserting, and that. So it's going to be one party asserting it, even if it's mutual mistake. So you're going to want to look for who is it that's injured here, and what are they trying to argue? Is it a mistake that both parties made at formation, or just one, and then follow the proper path there? So I hope that's helpful, despite some hiccups there along the way. And as always, if it is, do like and subscribe. Blessings to you and a good rest of the day. Talk to you later.